Hello and welcome to the BRR Legal Brief. I'm Kate Ritchie and today we're looking at the contract law reform discussion paper which was released by the Attorney General yesterday. Joining me to discuss the paper and some of the implications is Murray Deakin, who heads up the competition and regulatory group at Middletons. Murray, welcome.
Thank you, Kate.
Well, Murray, firstly, what's driving the argument for reform?
Look, I think the impetus for reform is multifaceted. Certainly there's a recognition that Australia's legal system diverges from the legal systems of many of our trading partners. Certainly there's a recognition that in the digital age, online trading has grown dramatically in recent years, and it may be time just to revisit our contractual law system.
And do you think that there's a need to codify or restate the contract law in Australia?
No, I don't, Kate. I think there's not a strong case for the reform of contract law in Australia. I think if you look at the number of cases reaching the High Court involving contract law, they are very few in number. Over the last 3 years, less than 5% of cases heard before the High Court involve contract law, and to my mind that does not indicate that there's a problem with Australian contract law.
Yep.
I think it doesn't suggest that there's difficulties with the interpretation or the application of common law principles in this country.
Well, it seems that it's settled, I guess, in the domestic space somewhat. But what about in terms of international transactions or cross-border transactions? Is there a case for reforming contract law in this area?
Yeah, I think there's a stronger case for further reform in the international theatre. I think we need to recognise Australia's prosperity is largely dependent on successful trade with our neighbouring countries. And I mentioned before, there is this divergence in the systems of law, particularly in Central Asia, civil law countries like China, Korea, even to a lesser extent India, which is a common law jurisdiction, has a level of codification of contract law. So I think looking across Central Asia, there is, I think, a desire, a need to do some further work to establish a central collection of contractual law principles which all trading partners should be invited to subscribe to. And that needs, we need to go out and engage with our Southeast Asian partners and get them to contribute to that debate so we can form some principles that everyone is content with.
Well, obviously, Murray, it's still really early days, but are there any options being flagged in terms of reform and also in terms of implementation?
Yeah, I think there are. The discussion paper sets out three possible ways forward in terms of contractual law reform. The first is a restatement of our current contractual law. As I said before, I don't think that's required based on the evidence that is available to me. Bear in mind also, Kate, that companies draw up their own contracts and they largely govern transactions, and in my own experience those contracts are reasonably well drafted and they proceed efficiently and without undue uncertainty. So I don't think a restatement of our laws is required. I think there's certainly a case for the simplification of some aspects of our laws. There's a plethora of Commonwealth, state and territorial legislation that impacts on contract law in this country, and some of those pieces of legislation really do need to be either repealed because they're outdated or simplified or harmonised. So I think that's an area that the governments of Australia can get involved with. The third option that's outlined is the reform of the substantive contract law. One would only embark on that journey if there was a real problem, and I'm not seeing that problem evident in the legal landscape of Australia.
Okay. And Murray, just finally, we've mentioned that it's early days, but what are the next steps, and do you think this is something that Australian business should be thinking about now?
Well, I think the Attorney General has released this discussion paper. She has invited comments from the business community, no doubt from the legal profession and no doubt from the general public. And I think those businesses that want to get involved with the debate, that want to shape the direction of future reform of contract law, should put in a written submission. There's a reasonably generous deadline. I think it's 20th of July for written submissions, and I would encourage our clients that want to get involved in the debate to make their views known, explain their own contractual experiences, and put forward some constructive solutions for how contract law in this country should be regulated.
Well, some good advice there. So everyone should get involved if it's relevant and write a submission. Murray, thank you so much for your insights today.
Thanks very much, Kate.
And viewers, of course, thank you for watching. We hope that you can join us next week for our next Legal Brief.